The United States prides itself on the Constitution that was written and signed in 1787 and has since governed our land. The Constitution was written as a protection for the U.S. citizens from abusive forms of power that had plagued Europe at the time. But how many adults could be able to name the first 10 amendments? The first 10 amendments, also known as the Bill of Rights, play a vital role in protecting our freedoms of speech, right to bear arms, freedom of unlawful searches and seizures, and the right to a speedy trial, and much more. Many of us hope to never have to use the Constitution as our form of protection, but if we ever get arrested, it may be our only saving grace. Our legal system is feeble at best, and while many may preach fairness, it falls short in many instances. This is due in part to the tricky language used in many previous laws that had been written. Many view the law enforcement as the good guys, the ones who will protect you from criminals. But what about the cases of mistaken identity, where the officer suspects the wrong person of committing the crime? Mm-hmm. You may feel that the justice system will prove your innocence, at least that's what you were told growing up, but that's not always the case. In the case of Cantrell Swift, he was 17 years old when he was imprisoned for 36 years for a rape he did not commit. He was later exonerated in 2011 from DNA evidence. This is just one example of many injustices that affect our legal system, but the Sixth Amendment grants us some protection through professional legal counsel. The legal protection granted to us is our best shield for what the court systems might throw at you. Let's say you've just been arrested and you arrive at jail. Your clock has officially started. After arriving at jail, you will be allowed to contact an attorney, and you have 72 hours to stand in front of a judge for your arraignment to take place. During the arraignment, the judge will then assign you a public defender if you could not afford a lawyer, read off the charges against you, as well as allow you to enter your plea of guilty, not guilty, or no contest. Each one of these pleas carry a different meaning. No guilty, or guilty means you did it. Not guilty means you didn't do it. No contest means you accept the charges and the sentencing, but you don't admit to the crime. Following a plea of not guilty, the judge will decide if bail is in order. If bail is allowed, bail is pretty much collateral in the monetary form that a defendant will show up for court. If they choose not to show up for court, they forfeit their bail and a bench warrant is sent for their arrest. At the end of the arraignment, the judge will set a date for a pretrial. The pretrial is where the prosecutor and defense attorney will both submit evidence supporting their side of the story. It is at this point if a judge will decide the state has met its burden of proof, and if the charges against the defendant, and if not, the charges against the defendant will be dropped. If the burden of proof is met, the official trial date will be set. While waiting for trial, the prosecution may choose to offer a plea deal in which could prove beneficial for both parties. While these deals differ from case to case, they range from incentives such as a year off your sentence to full transactional immunity, which protects you from the prosecution for any crimes you may admit while testifying in court. If no deal is met and either side has witnesses they would like to have at trial, they must have a deposition hearing, which is where both lawyers get to cross-examine each of the following witnesses and then be allowed to leave. At the start of the trial, the prosecution will begin with opening statements, which mainly consist of introductions of themselves, followed by a general overview of the case they set out to prove, followed by the defense introducing themselves and explain how there are always two sides to each case. The prosecutor will then present evidence backing up that the defendant had committed those crimes. The defense will try and poke holes throughout their story, backing up that the defendant didn't commit those crimes. Once all the evidence has been presented and each side has had the chance to give their story, the judge will instruct the jury and give them a general overview of the law pertaining to this certain case. There is no set time on how long the jury may deliberate. They may take as much time as they'd like for each verdict, for each charge. Upon completing deliberations, the judge will call the court back in session and ask the jury if they have found a verdict. If no verdict was found, a mistrial will be declared and the prosecution will have to refile charges. If they were able to reach a verdict, they will hand the paper over to the bailiff, who will then pass it over to the judge. The judge will ask the defendant to rise and read the verdict for each charge. If found guilty, he will read the sentences following each charge. If not guilty, the charges are dismissed and he must wait to be released from jail. That just about wraps up the main portion of the trial now. Now follows the post-trial process, which allows the defendant to file an appeal. An appeal is pretty much a formal letter asking a higher court to review the case because they felt they had an unfair trial. If they found it was unfair, they could reverse the verdict and order a new retrial, or if they found the trial was fair, the lower court's decision will stand. Laws, whether we like them or not, help them govern our society. While there has been a learning process creating and enforcing new laws over the course of our nation's history, we have always fell back on the Constitution as our final say. One example of this is in our landmark case of Brown versus the Board of Education in the Supreme Court, where the Supreme Court had reversed a decision they had made 6 years prior, which coined the term separate but equal. And in this case, they decided it was against the 14th Amendment to segregate children in public schooling. While our legal system is feeble at best, we continue to learn and grow, giving it our best shot at fair justice.